Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Achieving a gorgeous grin from home isn't a total mystery with Bite Clear aligners. Just don't be surprised if all of your sleuthing friends start asking, "What's your secret?" Begin by ordering your at-home impression kit today for only $14.95. Bite Clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces. Plus, they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning. This episode contains discussion of murder.
It's been a while since we did an episode dedicated solely to the University of Idaho murders, so it seems time for us to talk about that. This quadruple homicide, of course, included victims Ethan Chapin, Kaylee Gonsalves, Madison Mogen, and Xana Kernodle. These are 4 young University of Idaho students living in Moscow, Idaho, who are in their home where the 3 girls lived and where Ethan Chapin was staying with his girlfriend, Xana Kernodle. They're murdered overnight by an assailant, and ultimately a PhD student named Bryan Kohberger, who was across the border in Washington at Washington State University, is arrested for the case. So what we've been seeing unspool over time is the judicial process where he is being accused of these murders and we are going towards a trial. So recently, Kohberger's team tried to make the move to dismiss the indictment against him. We're going to talk about that, and we're going to talk about what ended up happening with that. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the University of Idaho murders. Bryan Kohberger tries to get the indictment thrown out. So on December 15th, a number of filings came in on this subject. And spoiler alert, Kohberger's gambit did not pay off. The indictment has not been dismissed.
And to be realistic, there was very little chance that it ever would have been. But there's a cliche we often use on this show. You miss 100% of the shots you don't take. And it's just diligence on the part of a defense attorney to try all of the available avenues they can to try to help their client.
Yeah, this is one problem I see with tea leaf reading in the true crime space sometimes. I feel like I've seen comments at different times or heard chatter where, this happened in court, therefore we should assume this. I'm not talking about this specific situation, but there's a limit to that, because if you were to look at them attempting to get the indictment thrown out, you'd be like, wow, the fact they're doing that means it's really a weak, probable cause and it's all falling apart. No, the defense attorneys are simply doing their jobs, and you have to try for that. So in this case, the exploit that they were taking was issues with the grand jury instructions regarding his indictment. So that's the sort of portal they saw open that they tried to rush towards.
So let me see if I understand. So he basically, Bryan Kohberger is facing charges because a grand jury handed down an indictment. And so his defense team is alleging that the instructions given to that grand jury were in some way flawed, and that, in fact, they were so flawed that renders any indictment they handed down moot.
That's correct. Specifically, the flaw with the grand jury instructions, according to Kohberger's team, was that they were told you need probable cause rather than you need beyond a reasonable doubt. Now, probable cause is a lower standard than beyond a reasonable doubt in this case. You have to jump over a higher hurdle to get to beyond a reasonable doubt.
Probable cause is what you need when you want to search someone's residence or when you want to arrest someone. Beyond a reasonable doubt is when you want to convict a person of a crime. And so the consequences of having your house searched or even being arrested are not nearly as severe as the consequences of being convicted of a crime. So it makes sense that being convicted of a crime needs to be as difficult as possible.
Absolutely. And so Kohberger is arguing this needs to be dismissed because they did the wrong standard. And it sounds like there's no dispute that they were going for a probable cause standard here. But what the state is arguing is that it's totally fine to do probable cause for an indictment. And that's settled. That's what we do in Idaho. So there's kind of a acknowledgement that that's what happened, but basically saying that's what we always do.
So they're saying basically there wasn't any error here. This is just standard operating procedure.
That's correct.
So if that's the case, why was the defense even trying to make an issue out of it?
They were pulling things out of the Idaho Constitution. So it seems like they were at least hopeful that they could make some sort of legal argument here that maybe we should do things a little bit differently. And I will say, though, that in his response to this, I'll read a little bit from the order denying motion to dismiss indictment for inaccurate instructions to grand jury that Judge John Judge filed on December 15th, because he kind of takes Kohberger's team to task a little bit, I would say, about some of their interpretations.
That's interesting.
Kohberger first relies on the Idaho Constitution and the plain language of the statute for his argument. Article 1, Section 8 of the Idaho Constitution in part states that no person shall be held to answer for any felony or criminal offense of any grade unless on presentment or indictment of a grand jury or on information of the public prosecutor after a commitment by a magistrate. This language obviously does not define the standard of proof for the grand jury, but Kohberger claims the language of Idaho Code Section 19 to 1107 does. Here's the entire statute. The grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. Again, this statutory language does not state that the standard of proof is beyond a reasonable doubt, the legal standard of proof for a criminal jury trial. However, Kohberger asserts that warrant conviction means that to find an indictment, a grand jury must find the accused guilty beyond a reasonable doubt. First of all, the word warrant carries many definitions. For example, the plain language of warrant means justification for an action, grounds. Also, other examples are consistent: justification for an action or belief, grounds; something that provides assurance or confirmation, a guarantee, proof; to provide adequate grounds for, justify; synonym of justify; to demonstrate sufficient legal reason for an action taken, synonym of warrant. Black's Law Dictionary also defines warrant to justify. The conduct warrants a presumption of negligence. These definitions have not significantly changed for over 100 years. Thus, the plain language of the word warrant easily means that, after hearing the evidence, a grand jury would, in their judgment, be justified to send the accused to a trial by jury. Kohberger seems to miss this additional language of the statute, by a jury trial. The additional language provides the broader context of warrant a conviction by a trial jury, not a grand jury. One definition of probable cause is reasonable ground for belief in the existence of facts warranting the proceeds complained of. This is precisely what grand juries are charged to determine. The grand jury is not a trial jury. Its function is to screen whether or not there is sufficient evidence to proceed to trial. The grand jury is baked into our United States Constitution, Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. And our Idaho Constitution, Article 1, Section 8, see language above. And the procedures of the grand jury have evolved over the years. Does that sound like the judge basically being like, you guys were interpreting this completely wrong?
Yeah.
I mean, the fact that he's pulling out some dictionary definitions. He's schooling them. I mean, they had to try.
Well, it's not unreasonable to try. I don't know if that you have to try everything.
Maybe you don't have to try everything. Maybe sometimes you should not try things because it just ends up looking kind of stupid.
And if you try things that literally have absolutely no reason of success, and you try things that end up getting a judge to start citing dictionary definitions at you, you do run the risk of alienating the judge.
Ooh.
So there is a line to walk there. You want to be diligent. You want to try everything you can that's reasonable. But if you go too far,
this seems like it was in a gray area of reasonability to me. Like, I can understand why they tried it, but it really seemed to be getting into, like, let's play around with language. It seemed to be getting into the kind of legalese nonsense that people hate when lawyers do. So, no offense, Kevin. You know, and to the point where it's like, I think I've grown to understand more of those methods and strategies from talking with you and from covering some of these cases. So I'm more sympathetic to that now than I was maybe a few years ago. But this is borderline at the very, that's a generous term in this, because he's indicating like this is completely settled law. You're doing a lot to misinterpret one word and read an entirely different meaning into something that is settled law. And so that when people say, oh, well, you know, the defense attorneys wouldn't try this, they have to be completely truthful and accurate and everything, you know, they can stretch. I mean, that's what we're seeing here. This is a friggin' stretch. And that can maybe pay off sometimes, but in other cases, it just gets slapped down. I mean, prosecutors can stretch too. In some cases, you might say, well, they're overcharging this person. It's a stretch to charge them with this. So both sides can be guilty of that. But in this case, I think it's the Ann Taylor-led defense team that is guilty of it.
If you're shopping while working, eating, or even listening to this podcast, then you know and love the thrill of the hunt. But are you getting the thrill of the best deals? Rakuten shoppers do. They get the brands they love with the most savings and cash back. And you can get it too. Start getting cash back at your favorite stores like Urban Outfitters, Samsung, and Adidas, and even stack sales on top of cash back. It's easy to use, and you get your cash back through PayPal or check. The idea is simple. Stores pay Rakuten for sending them shoppers, and Rakuten shares the money with you as cash back. Download the free Rakuten app and never miss a deal. Or go to Rakuten.com to start getting the most bang for your buck. That's RAKUTEN.
In fairness, Judge does acknowledge that there might be some ambiguity in some of this, so I think he's acknowledging maybe why they went for this. Even if there is some ambiguity to Idaho Code Section 19 through 1107, the case law in Idaho seems to be settled on the standard of proof for a grand jury to approve an indictment. While there is not an abundance of early appellate cases directly addressing the standard of proof for indictment, the available cases consistently reference the standard to be probable cause. In Gasper versus District Court of the 7th Judicial District in and for Canyon County, the plaintiff, the defendant in the lower court, claimed that the indictment should be dismissed on the grounds of various alleged errors in the proceedings of the grand jury. Court denied the claims as insufficient and not prejudicial to the plaintiff, who had been charged with a second-degree murder. Related to this case, the plaintiff, for some reason, challenged the instructions given to the grand jury, part of which stated, "You are not compelled to go under public trial in open court before a trial jury unless you are satisfied beyond a reasonable doubt from the evidence." The court recognized that the charge the grand jury had no bearing on the plaintiff's complaints because the charge was to the plaintiff's advantage. However, we observe that the charge complained of, though erroneous, is more favorable to the one accused before a grand jury than would be a charge embodying the statute, citing Idaho Code Section 19-1107. The language remains the same today. The charge as given calls for a greater degree of proof to justify an indictment that the statute requires. While this may be dicta, it does acknowledge the Supreme Court's view of the standard of proof for an indictment. A more recent and more definite acknowledgement of the standard of proof for an indictment is expressed in State versus Edmondson. The Supreme Court states clearly the purpose of the grand jury, including the standard of proof. The grand jury is an accusing body and not a trial court. Its functions are investigative and charging. The purpose of both a grand jury proceeding and a preliminary hearing is to determine probable cause. And again, the purpose of a grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt and innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports the finding of probable cause, it is not for an appellate court to set aside the indictment. And finally, without even considering the evidence used to find probable cause, we note that the prosecutor directed the grand jury that it should not indict unless all the elements of an alleged crime are proven beyond a reasonable doubt. This is a much higher standard than is required by Idaho law. That's pretty devastating for their argument. Yeah. All of that is just, again, hammering, it's probable cause, it's probable cause, it's probable cause.
One thing that jumped out at me from that is I always wonder what legal terms people are familiar with and what legal terms they're not familiar with, because it's very confusing to hear discussions where words are thrown out that you don't understand through no fault of your own just because you didn't go to law school. So I'm curious, there was a line in there, something to the effect of, oh, this wasn't an opinion, it might be dicta. Do people know what dicta is?
I don't know what dicta means. I was going to ask you because I was like that whoosh, flying over my head over here. I don't even know if I said it right.
Not the former coach of the Chicago Bears.
They're dragging him into this mess.
Dicta is language used in a judicial opinion by a judge that isn't necessary to reach the judge's final decision. It's just something they throw in.
Like a little flourish.
Yeah, basically. What you do in a judicial opinion is you make your decision and you explain the reasoning that leads to that decision. That's basically all you need to do. But oftentimes people, when they're writing opinions, will include other things, either for color or just to be interesting. If I happen to be writing a judicial opinion about baseball of all things, and I casually mention in the course of the opinion as I'm explaining my reasoning, the Chicago Cubs are a great team. And then I'm on a Supreme Court situation, I'm in a Court of Appeals situation, I'm sending my opinion around. The fact that other justices might sign on to that opinion doesn't necessarily mean that they agree with me that the Cubs are a great team. And when the opinion is issued, it's not going to be seen as being held by the court that the Cubs are a great team. It's just something that's thrown in there.
You're just freestyling.
What's important is the final decision and the reasoning used to meet it. And what can be complicated and confusing sometimes is it's not always clear what is dicta and what's not.
How does one determine that?
You just have to analyze it and say, is this line here in this opinion, is it necessary to explain the reasoning?
Okay.
Does that make any sense?
It does make sense. It does make sense. And can things get complicated when there's disagreement over what's dicta and what's not?
Yeah.
Is it dangerous to include it, therefore? Or
I don't know if it's dangerous to include it.
Kevin's saying that we have to all rule that the Cubs are the best team of all time. But there's some committed Mets fans on this bench.
Don't get me talking about 1969. It can be a little confusing, not necessarily terribly confusing, but it can be a little confusing. And also, it can often be seen as being potentially helpful. Let's say, in my opinion about baseball, I'm trying to analyze how we should handle something about professional baseball teams. And maybe in the opinion, I say something like, well, football is also a professional sporting league. I wonder if some of these things might apply to football. People then, when a football case comes up, could say, this baseball case, they say it might apply here too. Maybe we should look at that. So it could open up avenues.
I see.
Yeah, and the reason I bizarrely used a baseball comparison is I was as you were talking, I tuned out a little bit after you said dicta. So
wow.
Because I was trying to think of a good example, and I'm remembering, and all these details might not be correct, but there was a case involving baseball players' free agency. When are baseball players allowed to leave one team and go to another, and so on? It actually reached the Supreme Court, and the decision that was handed down in that case, again, this may not be completely accurate. It started off by saying something like, "There've been many great players in baseball," and it started listing players. Kurt Flood, so and so, this guy. And almost as a joke, one of the other justices said, well, you need to include a player from this team too, from my favorite team. So then the first justice who was writing the opinion said, okay, and put in another player. And obviously, a list of great baseball players does not have anything to do with the reasoning used to reach the decision in that case. And I believe the story of that decision and that incident, I may have gotten it years ago from the book The Brethren by Bob Woodward and Scott Armstrong.
What's that about?
It's about the inner workings of the Supreme Court in the 1970s.
Oh, there you go. The Brethren. Well, that's very interesting. And I appreciate you flagging it because I had no idea what dicta meant. Sounded Latin, sounded fancy.
So in other words, it's not binding. What courts put in a case as dicta is not legally binding, but it's potentially persuasive. If the comment the judge makes is not necessary to reach the conclusion of the case, but it's still somehow related to the case, it's just not off the wall like my baseball examples, then lower court judges can still look at it and say, well, that makes sense. It is persuasive. I don't have to follow it exactly, but it is persuasive because it wasn't this opinion. I really rambled there.
No, it's good. I feel like I'm learning stuff, so I appreciate it. Now, let's get to the conclusion of this portion, and then we'll talk about the other mode that the defense used to try to get this indictment dismissed. But the arguments from the defense for a beyond reasonable doubt standard for the grand jury were historically interesting and creative, but do not overturn Idaho court's interpretation of the statute, the case law, and the criminal rules, specifically Rule 6 through 6.8 ICR, that the standard for the grand jury to indict is probable cause. Therefore, the court denies Kohberger's motion to dismiss the indictment based on his claims of inaccurate instructions to the grand jury in order to warrant an indictment. So ordered this 15th day of December 2023, John C. Judge, District Judge. Okay, so they got They got shot down on that front. But they had another trick up their sleeve. They were going for a motion to dismiss indictment based on the grounds of a biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. Before we get into this side, what did you make of him calling it interesting and creative? That sounded like a teacher being like, oh, you tried.
Yeah, that's not necessarily what you want to hear. You want to hear like, oh, that was really persuasive.
It was thrilling. That was a neat try, guys.
Yeah.
Jeez. I'll get into this. Is a pretty short filing by the judge. This is actually slightly the actual decision. The order part is only like a page and a quarter. So I'll just read it. On August 23rd, 2023, Kohberger filed a motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct in withholding exculpatory evidence. On September 14th, 2023, the state filed an objection to defendant's second motion to dismiss indictment. On September 20th, 2023, Kohberger filed a reply to state's objection. A hearing on the motion was held on October 26th. Kohberger was represented by Ann Taylor, J. Logston, and Elisa Massath. The state was represented by William W. Thompson Jr., Ashley Jennings, Jeff Nye, and Ingrid Beatty. This hearing was closed to the public and media cameras to protect the secrecy of the grand jury proceedings. The decision will also be sealed. However, the results of that decision are addressed in this public order for the public's benefit. Kohberger has failed to successfully challenge the indictment on grounds of juror bias, lack of sufficient admissible evidence, or prosecutorial misconduct. Kohberger was indicted by an impartial grand jury who had sufficient admissible evidence to find probable cause to believe Kohberger had committed the crimes alleged by the state. Further, the state did not engage in prosecutorial misconduct in presenting their case to the jury. Dated this 15th day of December, 2023, John C. Judge, District Judge. So we don't get a lot of information here about why the judge made this finding. Because the grand jury element. Why is that supposed to be so secretive?
There's a lot of reasons for why stuff before a grand jury is secret. The most obvious answer is that it often includes confidential information about witnesses' identities and what they might testify to. It's also testimony that is not challenged by someone from the opposing party. It's one thing when you have someone offer testimony in a public setting in court because both sides get a chance to cross-examination, but that doesn't happen in a grand jury setting.
Okay, so this is we're not going to really know much about why this happened, I suppose. But again, he's shooting them down on all counts.
Yeah.
But we do get less legal reasoning as to why for that reason. What do you make of the defense side accusing the prosecution side of prosecutorial misconduct? Is that a tool that is frequently used? Is that something that is more of an extreme move? I'm just curious.
It's not totally unheard of. A lot of attorneys view criminal trials to an extent like professional wrestling. They're just playing roles. And you have to make somebody a villain, and defense attorneys really have limited options into who the villains might be. And if you want to argue that your client is innocent and shouldn't be charged, there's only a limited number of ways you can make that argument. And one is the prosecutors have really screwed this up.
Mm-hmm. That makes sense. So, tool in the arsenal here.
Yeah.
But I'm going to say this, like, we've seen these two attempts to dismiss the indictment fail. They failed. And that's not surprising to me. I think the evidence that's stacked up against Bryan Kohberger is pretty overwhelming. And I think I'll be interested if they keep on, sticking to this strategy going forward, as opposed to maybe trying to make a plea deal.
Yeah, it will be interesting. At least now they seem to be taking the idea that their client is actually factually innocent of these crimes.
Yeah. Again, the evidence, there's a lot of bad facts in here for Kohberger. It's not a good, this is not a good situation for him or their team to be in, frankly. Now, I wanted to bring up some other news items in this case. There's been a lot of back and forth about the house where these kids were murdered. Back in October 31st, 2023, Fox News, specifically reporter Adam Sabes, came out with a piece about how the FBI agents were returning to the crime scene to, look for more evidence and compile that. I guess I'm assuming make sure that they have everything or that they've mapped everything out appropriately. But the house itself is actually slated to be destroyed on, I believe, December 28th. And there's been a lot of online outcry about that. People are saying that you shouldn't do that until after the trial's over because it might be evidence lost, things like that. I know that Xana Kernodle's mother is even weighed in saying she doesn't want it destroyed. I can understand the emotional impact of that and the fear over losing something. Personally, I don't understand this. If the evidence should have been gathered by now and everything should have been mapped out on both sides. We know that recently the defense team also showed up at the site to, again, go over it one more time before it's destroyed. I don't really understand.
Is there a reason why it has to be destroyed now?
I actually don't know. So you're saying maybe leave it until after trial?
I don't think it would be necessarily damaging to the case to go ahead and destroy it.
I don't think it matters at all.
But I'd like to see it kept until after the trial, because there's always the possibility of things coming up, and there's always the possibility of something being relevant later that we don't know about now. And maybe the odds of that are long. Maybe it won't happen. But what's the harm in keeping it up for, another 3 or 4 months or a year, or however long it is?
I mean, personally, I feel like if they didn't get specific evidence now, then I don't even know what would be admissible or what could be argued. Well, maybe that was planted later.
But why the rush?
I mean, if it's someone's property, they might just be looking to get rid of it, given what happened there. I can understand that. And to be very clear, both the prosecution and the defense in this case have said that they don't care that it's being demolished. So I think they should be, if one side was saying, no, don't do it, then I think I'd be more sympathetic. Here's another element of this that has been filed in this recent slate of filings. Actually, this was filed yesterday on December 21st, 2023. This is from the Latah County prosecuting attorney, specifically his office, but specifically Senior Deputy Prosecuting Attorney Ashley Jennings. And this gives us a sense of what might happen next in this case, and maybe when we can expect some things timing-wise, although obviously it's undetermined. It comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for a scheduling order addressing without limitation the following. 1. Scheduling a jury trial to run for approximately 6 weeks, including penalty phase. The state proposes that the court schedule trial for the summer of 2024, and that the trial dates avoid times when Moscow High School and our area universities are in session. As the court is aware, Moscow High School is directly adjacent to the courthouse premises, and already the significantly increased amount of media and other vehicles related to this case has strained available parking, as well as the safety and convenience for pedestrians, including students. Court is also aware that when the local universities are in session, it is not infrequent for area lodging to become unavailable due to university-related activities such as sporting events, graduation, etc. The state also requests that the court set a daily trial schedule of 8:30 a.m. to approximately 3 p.m. For a trial of this length, it is appropriate to afford jurors some amount of time to tend to their personal affairs. Additionally, having more time in the afternoon allows for better preparation by the parties and allows for reasonable opportunities and time for the court and counsel to address any motions or other matters that routinely arise during the course of jury trials. In the state's experience, this type of daily trial schedule is typically appreciated by jurors as well as the court staff and counsel. 2. Deadlines for completion of discovery for both state and defense. 3. Deadlines for both parties to make expert disclosures pursuant to ICR 16b7 and C4. 4. Deadlines for filings of pretrial motions and responses and replies thereto, including but not limited to motions in limine, motions related to the death penalty, and any motions under ICR 12b. 5. Deadlines for jury questionnaire proposals. 6. Deadlines for proposed jury instructions. 7. Deadlines for proposed witnesses pursuant to ICR 16b6 and C3. 8. Deadlines for Rule 404b notices. 9. Dates for pretrial motions to be heard. 10. Any other matters to facilitate the orderly progress of this case and trial. The state notes that in this court's August 22nd, 2023 scheduling order, the court set a date certain for sentencing disclosures, including witnesses, exhibits, expert reports, and any other evidence. State requests that the court allow the parties further opportunity to supplement their disclosures following receipt and review of the opposing parties' initial disclosures. The court's August 22nd, 2023 scheduling order also directed the submission of trial exhibits and names of witnesses. The state again requests that the court afford the parties the opportunity to supplement those responses after they have had the opportunity to review and consider the initial submissions of the other party. In its August 22nd, 2023 scheduling order, the court afforded the defendant an additional opportunity to provide notice of alibi in accordance with court rule and statute. The state submits that the defendant has already been afforded this opportunity and the court heard argument on the motions relating to such. The state submits the opportunity for the defendant to disclose an alibi and notify the state of the same has passed and asks that the court not reopen this issue. If it would help in identifying dates and scheduling, the state would recommend that the court scheduled a status conference on the record for the purpose of scheduling. Respectfully submitted this 21st day of December 2023, Ashley Jennings, Senior Deputy Prosecuting Attorney. This strikes me as the state saying, let's get this show on the road.
I read it the exact same way.
Like, let's get on with this. They're thinking strategically about when the best time to have this trial would be. They're proposing the summer. That makes a lot of sense to me, given that it's a college town and it's right next to a high school.
Well, one thing we can certainly expect is that in the weeks and months to come, there'll be further developments in this case as we move closer and closer to trial, and we will try to keep an eye on them and keep you all updated. Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.